Colombia has developed a comprehensive data protection regime that aligns with international standards, protecting individuals' privacy rights while regulating the flow of personal data within its borders and beyond. This framework is grounded in the Colombian Constitution, which expressly recognizes the right to privacy and habeas data, establishing the foundational principles for data protection in the country. Foundational laws and regulatory bodies. The cornerstone of Colombia's data protection legislation is Statutory Law 1266 of 2008, focusing on the handling of personal data in credit and financial contexts, and Law 1581 of 2012, which provides the general framework for personal data processing across various sectors. These laws delineate the scope of personal data, categorizing it into public, semi-private, private, and sensitive data, each subject to different levels of protection and consent requirements. Law 1581 of 2012, in particular, emphasizes the importance of consent for data processing, mandating that data controllers must obtain clear, informed, and unequivocal consent from data subjects before processing their personal information. This law also establishes the rights of data subjects, including the right to access, correct, update, or delete their personal data, and the right to revoke consent at any time. International data transfer regulations. A significant aspect of Colombia's data protection laws is the regulation of international data transfer. The law restricts the transfer of personal data to countries that do not provide adequate levels of data protection, similar to the standards upheld in Colombia. This provision ensures that Colombian citizens' data is protected globally, aligning with the European Union's General Data Protection Regulation (GDPR) principles. Enforcement and compliance. The Superintendence of Industry and Commerce (SIC) is the primary regulatory body overseeing data protection compliance in Colombia. The SIC has the authority to investigate and penalize non-compliance with data protection laws, ensuring that entities adhere to the established standards. Sanctions for non-compliance can range from warnings and fines to the suspension or cessation of data processing activities. Challenges and developments. Despite its robust framework, Colombia faces challenges in fully implementing and enforcing data protection laws. The rapid advancement of technology and the increasing sophistication of cyber threats pose ongoing risks to personal data security. Additionally, there is a need for continuous awareness and education among businesses and individuals about their rights and obligations under data protection laws. The Colombian government and the SIC are actively working to address these challenges, including updating regulations to keep pace with technological advancements and conducting awareness campaigns to educate the public and businesses about data protection. Conclusion. Colombia's commitment to data protection reflects its dedication to safeguarding individuals' privacy rights and personal data in an increasingly digital world. Through its comprehensive legal framework and the efforts of regulatory bodies like the SIC, Colombia continues to strengthen its position as a leader in data protection in Latin America. As technology evolves and the global data landscape changes, Colombia's data protection laws will likely continue to adapt, ensuring that the rights of data subjects are protected in the face of new challenges.